Your motion is granted.
Thank you, Judge.
Good morning, Your Honor.
Good morning.
From the National Bar. I represent the estate. This is an exception to a claim which was filed by Cornerstone Bank.
Anyone here to prosecute the claim of Cornerstone Bank? No one here to prosecute the claim. Your exception is granted.
Thank you, Your Honor.
Thank you. You good? And how do you pronounce that? No. Is it monument or monument? I always try to take a sample from the lawyers in the courtroom whenever this comes up because it's never been clear to me, and it may be my accent that's controlling it, but so you would pronounce it how?
I said monument, but I don't know. Yeah,
And
monument.
in Houston County where I grew up, we call it monument, but you know,
That's
it
probably
doesn't
right.
really- doesn't really matter. We both know the same thing we're talking about. So,
Yes.
all right. And this is basically your client, is that correct?
Yes, Your Honor.
I don't, since it's for monument of title, I don't see there's any reason to have to put on proof, but it is going to be admitted for the limited purpose of establishing the title to the property.
Thank you, Your Honor.
All right. I will sign your order.
Okay, thank you, Your Honor.
Oh, you need to do the back. Trust fund.
Paul Rutherford, pass it to the bail of the docket.
Morning, Your Honor.
Good morning.
This is Deji Adeni of the Nashville Bar on behalf of the petitioner, Erica Nolan. This is her petition for the appointment of an administrator ad litem in the estate of Marvin Harris. Mr. Harris is a defendant in an ongoing lawsuit with my client, Your Honor, and he died on November 26, 2025. We filed on December 2nd, 2025, a notice of suggestion of his death upon that record in that lawsuit. And at the time of his death, he resided in this county, holding both real property and personal property. Since he died, Mr. Harris, no probate has been opened on his behalf, neither are there any indications that the probate will be opened soon. Meanwhile, under Tennessee Code annotated 16-15-711, the petitioner is under a very tight window to substitute Mr. Harris in the ongoing lawsuit. So she respectfully requests that this court appoints an administrator ad litem so we could substitute them.
Well, obviously, under the statute, you'd be entitled to have an administrator ad litem appointed. You've left that blank. Do you have someone in mind that you wish to have appointed?
No, we do not. We It was our understanding that there was like a standing pool.
All of you who are over there in the corner hiding, you wave your hand. Well, this is a seriously advantageous opportunity for you to be appointed an administrator ad litem. So why don't we appoint you to represent them? You want to?
That's it. That's it.
Oh. I'll sign the order.
I am the administrator of this estate, and this is my notice of insolvency and motion to approve my fees and approve the proposed insolvent distribution of the estate. I have a proposed order. I'm not aware of any opposition in this matter.
Anyone here in opposition to these motions in the estate of Elizabeth Phillips? Being no opposition, then I will approve your request.
Thank you.
Good morning.
This is a motion to approve attorney's fees and reimbursement of expenses. My executor's not here, but she has no opposition to this. I've heard nothing from any of the heirs, and so I would request that you approve the amount totaling $3,038.42.
I find those fees to be reasonable and there's no opposition, so I will approve your request.
Thank you. I will draw my order and submit it.
All right, thank you.
Your Honor, that's my case. We're here on a motion for default judgment. Notice was sent to Mr. Hedgepath. He's not present. He was here the last time we were here, Your Honor. Parties were actually divorced back in October of last year. At that point in time, through the course of the divorce, Mr. Hedgepath had a significant issue with alcohol and with synthetic, as I call them, gas station drugs. He had previously had a drug problem. He went through rehab a number of times through the marriage. Then he professed to be clean, but was doing the kratom and the Delta 9 and then reverted to just alcohol. So Mr. Kurt Vandervoort represented him during the pendency of the divorce, and there were some other issues. So we went through a process where he used a ankle monitor, an alcohol ankle monitor for a period of time to stay sober and to stay clean. He successfully did that, and we ended up resolving the case back in October, where Mrs. Hedgepath was designated as the primary residential parent, but there were specific requirements set forth in the parenting plan. It was a graduated scenario, as long as after he successfully completed the interlock device and the alcohol suppression, the ankle monitor scenario. But we put provisions in there that it was specifically the father was not to drink alcohol before or during his residential time. He was not to use non-prescription medication, mild altering substances, including and not limited to, as I say, gas station or drugstore drugs and substances. Specifically, Judge, we put in the mushrooms, microdosing mushrooms, and any other illegal substance. The mother had the right to request an extended panel hair follicle test. She had the right to have a breathalyzer performed. And so he did good for approximately a month to a month and a half and then reverted back, wherein he was allowing other people around the children who were intoxicated. He became intoxicated with the children. In fact, over the holiday, an event occurred and he put the children outside in virtually freezing temperatures and told her to come get them. We filed a restraining order and we came before this court on on February 11th, for an extension of the ex parte restraining order. Mr. Hedgepath appeared. Mr. Hedgepath was placed under oath. I questioned him. He admitted that he was drinking during his residential time with the children. As it said in the court finding in the sworn testimony of both the petitioner and the respondent, that due to the respondent's drinking during his residential time with the children and other circumstances occurred, it was the best interest to modify his residential time pending a hearing where he only got residential time at the mother's discretion. She has allowed residential time when she is ensured that he is not drinking or subjecting the children to inappropriate individuals. There was a domestic disturbance at his home at one point in time where a gun was pulled and then the person that he had living there and was partying with was arrested. I think he's still in the jail here. But when Mr. Hedgepath came to court, I questioned him about that. He readily admitted all of that. And he admitted that he understood he had an alcohol problem, but he had no intention of stop drinking. He was just not going to do it around kids. He was given an opportunity to file a responsive pleading. All of that was testified to, and we're here now to move for a default judgment.
All right. You want to put your client under oath and
Yes,
you'll
Sean.
raise your right hand, please.
You're Misty Hedgepath, is that correct?
It'd be
And-
simpler if you just said ditto to whatever she just said, I suppose, but we need you to testify under oath about what's happened, so.
So, Ms. Hedgepath, you've heard what I had articulated to the court of what transpired after the divorce. He had an ankle monitor, and he did not violate and drink alcohol, do anything to your knowledge during that time. And then immediately after he got off, he reverted back to his old ways of alcohol and becoming intoxicated. We're not aware, haven't wasted the money to go do a 12 panel because he's admitted that he's drinking. He came before the court and admitted that he had violated the court order. Additionally, during this period of time, he was already adjudged being behind in his child support some $5,700. He was supposed to make a payment of $1,900 at the end of December. He failed to do that. He paid $1,000, but did not do it. He is also supposed to pay, I think today, $1,900. And then he has not paid any child support for January, February, or March. Is that correct? And based on the agreement we had with his attorney, his child support was set at $950, but he was to pay $200 towards daycare and $146 towards his portion of insurance. And he's failed to pay those payments. Is that correct? So as we stand here today, he's admitted before the court that he's violated the alcohol ban. He has failed to pay one payment to satisfy his past due child support. And then he has failed to pay child support and has a new arrearage of $3,888, which is the 3 months of the $950, the $200 daycare, and the $146 for insurance. Is that correct? In addition to that, he has made significant inappropriate statements to you and the children, threatening that your oldest son will be 12, I think next year. Is that correct? Or this November, and that he's just going to get him and he's going to come live with him. He stated he has no intention to quit drinking. And you're in fear of your children's safety. What led us to go and to get the restraining order was over the children's Christmas break. He had gotten into an argument with a paramour. Your son was having some significant difficulties, not sleeping. And he became enraged, called you, set the kids out on the steps in cold, freezing weather and said, come get them. And you had been, what time of night was that? 11:30. And he was supposed to keep them kind of for an, he couldn't stand it. He couldn't tolerate it. He just lost it. You believe he poses a danger to your children?
I know that he loves them, but I don't think he's able to take care of them the way he should.
And again, your parents have supported you, and in fact, his parents have also see it. If he's made threats against your father's life and against his own father's life when they try to come in and to offer fatherly advice. Is that correct? You believe a modification of the parenting plan is in order. You want to be your primary parent, and you want to do that, but you want to limit any residential time that he has to be at your discretion. You understand your kids, again, love their father, and that you want him to have a relationship with him, but you want it to be a safe relationship. And you're at this point in time able to manage that with the court order saying when, where.
Yes, I have been, I've breathalyzed him before and after his time with him, and I don't allow overnight.
And you've been able, I think you just even let him have some time this weekend.
I did. Since court, I've let him see them at least once a week, for several hours, like 3 hours. But I make sure that the breathalyzer is 0.00 before he takes them, and then he blows in it afterwards too. The only way I know it.
Right. And you understand that's your cross to bear at this point in time. Is that correct? And so you're wanting to modify that residential schedule. Additionally, you want to claim all the children as on the tax purposes before we had negotiated, because he was supposed to pay child support, but he's utterly failed in that endeavor. Is that correct? And you're also wanting to put in the provision, excuse me, that recalculate the support for 365 days to use 0 to him. And again, daycare expenses, it's 200 during the school year, but it will go up a little bit, and we're going to average those costs. You're going to get me those, and we're going to average those costs. And you're keeping health insurance, and we're going to include that. Neither one of you have any other children or any other credits that are entitled in the child support. And using your income that we just did, and when we calculated it, and his should be appropriate. And you believe that's correct? And you've incurred attorney's fees in this in the amount of $5,000, and you're asking for a judgment for that. Is that correct? That's our proof, Your Honor.
All right, based on the proof before the court, and the court grants the default judgment and also grants the relief sought in the petition, which is to modify the parenting plan to designate her as the sole person in charge of his visitation with the minor children. It'll be at her discretion. I will order that the child support be recalculated according to 0 days for him and 365 for her. In addition to that, she will be the sole person to claim the children for taxes, and she will be awarded her attorney's fees and court costs.
Thank you, Your Honor. Okay, I'll give it back.
We have a Laura League in the waiting room to come in on Zoom. You know what case she's involved in? Let me, Ms. Lee, can you hear me?
Yes, I can.
Oh, you need to turn your video on so that we can see you, please. Ms. Lee, can you tell me what case you're here for?
I am here for case number 19742.
And we're here down on Shell Point Mortgage Servicing versus Gene Brown, Pete,
Yes,
Mr. McKnight, and Summer. Is that correct? Okay.
oh,
It is the case that we're about to have the hearing on, so
oh,
this is a complaint to quiet title and for declaratory judgment. And the motion for default judgment has been filed against Gene Brown, Pete, Jason McKnight. Is that correct? You represent
Yes,
the
sir.
moving part?
Yes, sir. I'm here on behalf of Mr. Johnson for the plaintiff, Your Honor, Daniel Lewis.
And who do we have behind you?
Summer Company.
All right. And Ms. Lee, how are you involved in this?
I'm here on behalf of my mother, Jean Brown. I am her power of attorney, and I believe a copy of that document should be on file with the court.
Well, this is a motion for default judgment, and you want to state your reasons for your motion for default?
So two of the defendants were served in August of last year. One was served in September of last year. None of the three has pled appeared or responded to the complaint, nor have they filed a written response to this motion for default judgment, Your Honor.
What a motion for default means is that you were all three sued for the relief sought, which is to quiet the title and to declare that the mortgage that was held against the property was to be held null and void, and to therefore render a clear title to the moving party, which would be Shell Point Mortgage Servicing. And none of you have filed an answer to contest that. Do you understand that? And so all this is asking for, if I understand it correctly, is to hold that the property title be quieted so that the deed of trust reported on December the 8th, 2005 be released and no longer encumber the property. So is that, you all understand that?
Repeat that, I'm sorry.
Pardon?
Will you repeat that? I'm sorry.
Sure. This lawsuit is about quieting the title or clearing any encumbrance that might be against the property. So what the plaintiffs have done is they filed a lawsuit saying that the mortgage deed of trust that's still held on the property was never released, and it should have been released so that the present mortgage holder has clear title to the property. And all this is doing is, it's not holding anything against you. It's just saying, because you had some interest in the property at some time, the three of you, then this is saying you had to be given notice. What they're asking is that the mortgage lien by deed of trust that was recorded back in 2005 be held to be null and void and released because it was never officially released. So do you understand that?
Yes.
Your Honor, we're also requesting $5,300 in attorney's fees.
And that's going to be assessed against who?
I assume joint and severally.
Against who?
I assumed against Gene Brown, Pete McKnight, and Summer Utley jointly and severally.
Well, what basis do you have for attorney's fees to be awarded against these three people who? I don't personally find that I mean, that apparently they had some connection to this in years past, but absent some proof that they took action that encumbered this property against your client's interest, I'm not inclined to award attorney's fees against them for something they didn't do. So.
And I don't believe I have enough information to give you a satisfactory answer to your question.
Okay.
Apologies.
Well, your request for attorneys,
Years ago.
here's what we're doing. I'm going to grant their default judgment, but I'm disallowing a request for attorney's fees against the three of you because, to my knowledge, from my review, it doesn't appear that there's anything you did wrong in the case. It just somewhere along the line that mortgage deed of trust was never released. They're getting what they want, which is a clear title. And I don't find that there is a basis. I understand that under the law, a prevailing party can request an attorney's fees, but in this case, I'm using my discretion to say that I don't think any of these folks did anything to justify awarding of attorney's fees.
All right, understood, Your Honor.
Thank you. And you can
Thank you.
put that language in your order if you need to.
Okay.
So,
Thank you.
thank you. Thank you, Ms. Lee.
Thank you. Your Honor,
Yes?
I just wanted to state on my mother's behalf, she wasn't even at her home any longer when people were starting to look for her based on these documents. She left her home at the end of January 2023, and her house in West Virginia was sold at the end of April 2024. She has dementia and has been living in a nursing home in Virginia for a little over 3 years. If any of her family was aware of this, of people looking for her, we would have tried, we would have signed a quit claim. And I'm sorry, we just had no idea that any of this was going on.
I understand that, Ms. Lee, and my ruling is that the mortgage company is entitled to the relief that they
Yes.
sought. But I
Yes,
do not find that your mother did anything wrong that
Okay.
would justify awarding attorney's fees. So
Yes.
thank you for your input.
all right, thank
All right,
you.
thank you. All right,
Thank
thank
you.
you. Call the next case. Anyone here on the behalf of Clear Recon LLC? Motion for default and the motion for default to interplead funds. The motion is denied. Clear to prosecute.
Anybody here on delinquent tax? Your Honor, good morning again. I have two motions related to the delinquent tax case. One is a motion to dispense with personal service and serve by publication. We have several persons listed in there and the specific reason for each of the taxpayers. I would note that under the cases or the situations where we're asking to serve the heirs of certain persons, some of that is a belt and suspenders approach. I know the names of some, but possibly not all. So I want to make sure I capture them all in publication. My affidavit for publication is set forth with that motion, and I sent a proposed order when I sent the motion. So I'd ask that you approve that. And then the other one is a motion for substitution of parties due to the death of a defendant with respect to Janice Luther and Gerald Gish. I had obtained defaults on both of them, was actually quite close to moving towards including them in the tax sale when I happened to see their names on the local funeral home sign. And so I paused that. And so dug around, found some errors. And so I'm asking that those errors be substituted. I believe Ms. Salinas has actually opened the estate for Mr. Gish. So hopefully that'll get that resolved pretty quickly too.
Your motion to substitute parties will be granted, and your additional request or motion to serve by publication will be granted as well.
Thank you, Your Honor.
Morning, Your Honor. Gentlemen from National Guard. Your Honor, this is also my case to my client's motion to substitute parties. This was an old divorce file. Ms. Dupre passed away in March of 2023. We actually filed a notice of suggestion of death. And ultimately, we're substituting the estate as the party because we have an old quadro that was executed back when the divorce was finalized, and we're trying to get the quadro processed, but they need the estate substituted, and I felt like this was the easiest way for us to do that. Your Honor, I have an agreed order because Ms. Roberts is here today, and that's okay. We have an agreed order, not only agreeing to the motion, but also an agreed order which revises the domestic relations, retirement benefits order. And also some model language for you, Your Honor, that the plan administrator required for this. I sent it to his address right there.
That was right.
Very good. So I have 3 orders for Your Honor to sign, if you don't mind. That's good. That's good.
And then I found out my client's living in Columbia.
Yeah, in Cookville, yeah.
I'm so happy that I get to tell him that I was in.
Yeah, I tell you what, it does. Can you get for me the last 4 digits of his social?
I will.
I think I have to mail this in.
Yeah, I'll get it. I've got it in. I'll text my office right now. I'll get it.
Yeah.
Right, probably is in file, the exhibit.
Oh, yeah, okay.
We're looking at it right here.
Mhm.
You got the Dupree file? You, okay, the whole, you,
All right, I've signed all 3 of your orders.
thank you, Your Honor.
Thank you very much, Your Honor. Thank you, Ms. Roberts. Yeah.
Okay, this is my petition to declare the estate of Mr. House insolvent and notice of insolvency. Your Honor, this is Tiffany House. She is the spouse of the decedent and the administrator of the estate. And then Ms. Snow is the guardian ad litem for the 2 minor children of Mr. House. Your Honor, just a brief overview. There is absolutely no money in this estate to pay debts. We have 1 claim that's been filed by Centennial Medical Center, and then we have the cost of administration associated with the estate. Mr. House owned a house at Christopher Lane, 1012 Christopher Lane in Ashland City. It does have a mortgage that's associated with it, but we anticipate that there will be about $60,000 worth of equity. So we're asking that the real estate be brought into the estate so we can get it sold and pay the debts of the decedent.
Well,
If Your Honor wants.
you're the guardian ad
Yeah.
litem. Sounds like it needs, according to what you filed, it needs repairs anyway, and you don't have the money to do it, so you're gonna sell it
There's-
as is.
That's correct, Your Honor. There's a lot of work that needs to be done. There's some extenuating circumstances with the property and it needs to be sold. And ultimately that will benefit the children as well as get whatever debts there are paid.
All right,
So that
thank
was
you.
the-
We'll
Your Honor,
approve this.
not- I did not bring an order, but I'll file one
Oh,
this
thank you.
afternoon. Thank you.
Attorney Tamara Hill. This is a motion to force an interpleader. Motion is stricken for failure to prosecute.
Your Honor, this is Ms. Roberts and our case, and I think she's speaking to another attorney out in the hallway. We think we might have a resolution on this matter. If not, it may be a brief hearing, but we're anticipating a resolution.
All
I
right,
have a,
we'll put it on the second
Yes.
call and come back to it.
yes, sir, thank you.
Good morning.
Kristen, I represent the petitioner Lonnie Fairchild. This is our motion to determine the allocation of interest to the potential heirs. I have in my motion submitted the valuations that I believe are appropriate. I don't know that there's been.
You had any opposition? Anyone expressed that they should get more than what you've set up?
I have not.
Anyone here on the estate of, or actually on this partition action that opposes the allocation of interest as set forth by Ms. Knight in her proposed order? All right, I've reviewed it and it appears to me you'll be correct, so I will grant your request.
The motion also requests to specify for the partition for sale.
It will have to be partition by sale. I don't think you can do it by, in kind, so it will be
I would agree.
by public sale.
Thank you. I'll get the order submitted.
All right, thank you. Next case is Ms. Roberts. Let's just go ahead. The Phelps versus Phelps case. She's out of the courtroom. We'll come back to it on the second call as well. Are we ready on that one? John David Blair versus Greta Louise Blair. All right. Then if you're ready, I'm ready. This is an exception to the amended claim. What?
Oh, you need the tape? Okay. My office, I can tell. I'm being displaced from my office, Judge. Here.
So we have a claim filed by Greta Blair against the estate of John David Blair. And it's been an amended verified claim, and now that has been accepted to, if I understand correctly. But start it off by telling me who you are and who you represent.
I'll kick it off. Your Honor, Philip Irwin of the Nashville Bar. And Liz Clement and I represent the claimant, who is the surviving spouse of the decedent, Greta Blair. We're here today because of an interest that the decedent held, an ownership interest in Parthenon Plumbing. As the name would suggest, it's a plumbing company. Mr. and Mrs. Blair were married for 14 years before his untimely death in September of 2024. There are no children of this marriage, but there's one surviving daughter from a previous marriage, Mr. Blair's surviving daughter, and that's Caroline Crenshaw. At the time Mr. and Mrs. Blair were married, Mr. Blair worked for Parthenon Plumbing and Mrs. Blair worked for Raymond James, still works there. In 2021, an opportunity was presented to Mr. Blair to be able to buy into and become an owner of Parthenon Plumbing. And it would require a buy-in of $32,000. And like most people, they didn't just have $32,000 lying around. So they agreed between them that Mrs. Blair would borrow from her 401k the amount needed to purchase the ownership interest in Parthenon Plumbing for Mr. Blair, and she did so. And their agreement was that when the company began to issue dividends, that she would be paid back. That did not happen prior to his, as I said, his untimely death in 2024. So Mrs. Blair went ahead and borrowed the money and loaned it to Mr. Blair to invest in Parthenon Plumbing, yielding a 10% interest, Mr. Blair, in that company. You may be aware with 401ks, especially one sponsored by your employer, Raymond, or in this case, Raymond James, monthly deductions were made from paycheck until 2025, when by that time, Mr. Blair was deceased, and Mrs. Blair paid the remaining loan off with his life insurance proceeds, or a portion of his life insurance proceeds. Then in 2023, there was an additional opportunity for Mr. Blair to purchase an additional 9% interest in Parthenon Plumbing, which would require a payment of $18,668. On this occasion, they had the same agreement, but Mrs. Blair took a premature distribution because she had not reached 59 and a half years old. So she took a premature distribution of $26,073. And the reason it wasn't exactly 18,000 is because there was a little bit over $7,000 penalty owed to the IRS for liquidating a portion of her 401k. So she borrowed 26,000, or didn't borrow, she liquidated her account in the amount of about $26,073. So the total invested by Ms. Blair and loan to Mr. Blair was about $61,500. By the time Mr. Blair had passed away, the ownership interest had grown from the amount that Mrs. Blair invested in it to $198,500. There was a redemption agreement, and that money is now in the estate account and sitting there in the estate account. All Mrs. Blair is asking for here is a return of her investment in Parthenon Plumbing prior to the distribution of the remaining sum. And technically, there could be an equitable argument that she's owed all of it, because without her money, none of this would have ever been there. But all she's seeking is to get her initial investment back before the remainder of the money is divided among the surviving heirs. And that is what the proof, we believe, will show.
All right.
Good morning, Your Honor. Kristen Amonette of the Nashville Bar. May it please the court. Your Honor, I represent Caroline Blair Crenshaw in this matter. Miss Crenshaw is the only child of the decedent, John David Blair, and a beneficiary of his intestate estate, along with the petitioner and administratrix of the estate, Greta Blair, who was the decedent's wife. Your Honor, the decedent, John David Blair, he died unexpectedly on September 1st, 2024. And on January 27th, 2025, Miss Blair, so that's about almost 5 months later, his wife opened his estate for administration. And at the time of the filing of the petition to open the estate, Miss Blair asserted that the estate consisted of the marital residence, which was owned by tenants by the entirety, and some personal property in the amount of about $250,000. Because Mr. Blair died intestate, Miss Blair and Mrs. Crenshaw, by statute, TCA 312104, will share in the assets of the estate equally. There were 3 claims that were filed against the estate during the applicable claim period, Your Honor. One by Capital One for about $945, one by U.S. Bank for about $2,171, and a claim by Miss Blair in the amount of $51,500. Now, that was the initial claim, Your Honor, $51,500. That claim was later timely amended to also include a claim for interest and early withdrawal penalties for the 2 loans that Ms. Blair alleges consisted of this $51,500. The estate filed an exception to the Capital One and U.S. Bank claims, and those were ultimately precluded. The estate did not file an exception to Ms. Blair's claim. But on August 4th, 2025, Ms. Crenshaw did timely file an exception to the claim. Thereafter, Ms. Blair filed an amended claim and Ms. Crenshaw filed an amended exception. Those were all timely filed. The basis of Ms. Blair's claim, Your Honor, against the estate consists of two alleged loans that she provided the decedent to purchase an interest in the plumbing company where he was employed. So that's Parthenon Plumbing, Heating and Cooling LLC. Ms. Blair alleges that she provided the decedent a loan in the amount of $32,500 and a loan in the amount of $18,000 to purchase his interest or this interest in Parthenon Plumbing. The $32,500 loan was provided on July 28, 2021 via a loan against her 401k. The $18,000 loan was allegedly provided on September 13th, 2023 via a cash out of an IRA in Ms. Blair's name. Ms. Crenshaw filed an exception to Ms. Blair's claim because Ms. Blair did not provide any evidence of a writing documenting that the funds were a loan to Mr. Blair and that he committed to repay them. There was no promissory note provided, no loan agreement, nothing. In addition, Ms. Blair provided no evidence that the funds that she alleged she loaned the decedent were not repaid, either during the decedent's lifetime or after the decedent's death. In fact, in Ms. Blair's original claim filed with this court, she provides documentation of correspondence between herself and the president of Parthenon Plumbing that she is to receive $198,500 for Mr. Blair's ownership in the plumbing company. And as opposing counsel just testified, apparently she has received that money and it's in the estate. In and of itself, Your Honor, that's more than $50,500. Ms. Blair provides evidence in her amended claim that on July 31 of 2021, she took out a loan in the amount of $35,000 from her 401k. She provides documentation that on July 28, 2 days earlier of 2021, there was an electronic deposit into a checking account in the decedent's name from an account in her name in the amount of $32,500. The deposit is actually 2 days before the loan was originated. Now, there's no documentation that the funds deposited into the decedent's account are from the Raymond James 401k, or they're in fact a loan to the decedent, which he agreed to repay, or that the funds were never repaid by the decedent. No evidence, other than presumably Ms. Blair's testimony, which we'll discover as we proceed with this hearing. Ms. Blair provided documentation also in her amended claim that in 2023, she withdrew $26,073.36 from her IRA, and $7,822.01 were withheld, and that was the early withdrawal penalty. And then on 9/13/23, there is a deposit into a checking account in the decedent's name for $18,000 from an account in Ms. Blair's name. Again, though, there's no documentation that the funds deposited into the decedent's account are from this Raymond James IRA, that they're in fact a loan to the decedent, which he agreed to repay, or that the funds were never repaid by the decedent. In response to the request for production number 1 submitted by Ms. Crenshaw to Ms. Blair states there are no written promissory notes or loan agreements between claimant and her deceased husband. Tennessee law requires, Your Honor, pursuant to TCA 29-2101, that, and this is a quote, no action shall be brought upon any agreement or contract which is not to be performed within the space of 1 year from the making of the agreement or contract, unless the promise or agreement upon which such action shall be brought, or some memorandum or note thereof, shall be in writing and signed by the party to be charged therewith, or some other person lawfully authorized with such party. Your Honor, there's no evidence, and there's not going to be any evidence in this case here that there is a loan that is in writing. So there's no way to prove that there was a loan and that the loan had to be paid within a year. So the claim is going to be precluded on the basis that it's not in writing, pursuant to statute. Your Honor, there's no documentation or evidence provided by Ms. Blair that any alleged loan to her husband has not been repaid. Her own bank records, which were subpoenaed by Ms. Blair's attorneys, her own bank records show deposits into her accounts exceeding $74,000 between 7/21, the date of the first loan, and Mr. Blair's date of death. And that is excluding her paycheck or any income tax refunds. Since Mr. Blair's death, Ms. Blair has received life insurance proceeds, that I know of in the amount of $30,000 because that's in the bank records, a $19,000 income tax refund from the year of his death that was filed, married filing jointly, his 401k proceeds, their home, and proceeds in the estimated amount of $198,000. Apparently that's in the estate. This is the first I've heard of it, but it's good to know. Ms. Crenshaw's position, Your Honor, is that Ms. Blair's claim is precluded by TCA 29-2101 because it's not in writing. 2, it's otherwise precluded and should be denied because she has no documentation admitted by her discovery responses reflecting a loan to Mr. Blair and an agreement to repay Mrs. Blair. Her own checking account records show deposits exceeding the loan amount during this relevant time period between the first loan and Mr. Blair's date of death. And she has received well in excess of the alleged undocumented loan amount of $50,500 since Mr. Blair's death. Thank you, Your Honor.
You may put on your proof.
Yeah, if I may please, if the issue is a purely a legal one, I think we can dispense with the testimony and go forward. If it's a statute of frauds defense, there's plenty of authority that statute of frauds does not apply in this case. And if that's the objection, then
I think there were 3 objections. One of them was that one of the objections, if I understood it, was that it's precluded under 29-2101 because it's not in writing. Another was that there was no proof that there was an agreement. There was no proof that there was an agreement between Mr. Blair and Mrs. Blair that her deposit of those funds constituted a loan that would be repaid. And then the third one was, I think, that she's received more than those loans amounts in other assets or out of the interest of that. Now, I don't mean to speak for counsel for Ms. Cleveland, but I think that was what I understood. I don't care how you wish to proceed, but if you want to address the argument about the statute of frauds, then you may do so.
Your Honor, I understood the first 2 arguments, the fact that it violates statute of frauds and that there's no writing. Well, the statute of frauds does require a writing, so I saw those as both an argument of the statute of frauds because she's saying that it wasn't reduced to writing, therefore it's violated of the statute of frauds. And I've got legal research here that I can hand the board and hand to counsel that this partial performance takes it outside the statute of frauds. And there's just no way that anybody takes $32,000 out of their account or then takes an $18,000 premature distribution unless there is some sort of agreement to do that. Certainly not when it goes directly into her husband's business in order for him to acquire an ownership interest in that. So part performance, I mean, we can argue that maybe in closing.
They were married at the time this transaction took place, correct?
They were, but it was, the investment was in his name, but she put the investment into that for his.
And was the 401k or the money where she withdrew was that something that was acquired during the marriage and were marital funds by Tennessee law?
She already had that when she came into, I don't believe it would be because she already had that when she kind of came into the marriage. Now, obviously it grew during the marriage.
Right.
It was through her employer, so it did grow.
So the question would become, if she took a separate asset of hers and invested it into a company that they later acquired an interest in, even though it was held in his name, under Tennessee law, wouldn't it be marital property? The company?
Wouldn't it be marital property?
Yes. I hear this all the time in divorce cases
Yeah.
where you take, she's transmuted a separate asset by putting it into an asset that's acquired during the marriage. Marital property is all property acquired during the course of a marriage, unless it's acquired by separate, that it's separate property or that it is inherited property or something like that. So my question is, what is the legal significance of the fact that she took a separate asset, money from her 401k, and invested it in this company, gave it to her husband, and then her husband bought an interest in the property that was in his name only? But clearly, that interest in the property under Tennessee law would be considered to be marital property because it was acquired during the marriage. So that interest in that property, in that company, acquired through perhaps the use of her separate monies, was marital property. And then that marital property, upon his death, she inherited all of that. Is that correct?
She did not inherit it. She had it paid into the estate. So it's being held in the estate. I think you could make an argument that it is solely her property. We're not making that argument. All we're asking for today is that the money that basically all of this money came from, the original investment be paid back before the remaining money is split with Mrs. Crenshaw or with Ms. Crenshaw. So she's just asking for her investment in the company
Understood.
back before the rest of it's distributed. I think you could make an argument that it solely belongs to her, but out of an abundance of caution, we had it deposited into the estate account so we could bring it before the court.
All right. You wish to respond? I mean, obviously, they're arguing part performance as being an exception or removing it from the statute of frauds. And I'll consider that at the appropriate time. But if you want to put on your proof, we'll let you do that.
We'll do that. And I'll provide the legal case, the legal authority upon which we rely. Look for consideration. We'll get to that after the testimony.
Good morning, Your Honor. Mary Liz Clemens of the Nashville Bar, representing Ms. Blair alongside Mr. Irwin. I'd like to call our client, Ms. Blair, to the stand.
All right, Ms. Blair, if you'll come around to the witness stand, please.
Thank you.
Step right around here. Be careful. You'll stand and raise your right hand and be placed under oath.
Good morning, Ms. Blair. Please state your name for the record.
Greta Louise Blair.
Say the first name again, just to
Greta Louise Blair.
make sure Madam Court Reporter heard that. And please state your address.
206 Hudson Drive, Gallatin, Tennessee.
Have you been married before?
No. I mean, not before John David.
Right, but
Yeah.
before in general, yeah. Okay, who are you married to?
John David Blair,
And how long were you all married?
14 years,
And you were together before you got married, how long?
about 10.
Did you and Mr. Blair have any children together?
No.
Did Mr. Blair have any other children?
Yes.
When did Mr. Blair pass away?
September 1st, 2024.
And what do you do for your career?
I work at Raymond James. I'm a sales assistant.
What did Mr. Blair do?
He worked at Parthenon Plumbing and was part owner.
When did he start working at Parthenon Plumbing?
I don't know the exact date.
An estimate is fine, just around.
I don't know.
Okay, well, we can deal with that later. What did he do at Parthenon Plumbing?
New construction.
And do you know whether Mr. Blair owned any part of Parthenon Plumbing at the time that you all got married?
No, he did not.
What was the date of your marriage?
October 9th, 2010.
And during your marriage, did Mr. Blair actually have an opportunity to buy into Parthenon Plumbing?
Yes.
Around what time did he first have that opportunity?
2021.
Did he have to make an investment to obtain ownership?
Did he have to make an investment?
To obtain an ownership interest in Parthenon?
Yes.
What was that amount?
32,500.
And did he have that amount to invest on his own?
No.
So do you know how he obtained the money to make that investment?
Yes.
How?
I took a loan from a 401k.
And who held your 401k?
Principal through Raymond James,
And how long have you had that 401k?
about 30 years.
Have you worked at Raymond James that entire time?
Correct.
Okay.
I'm sorry, how long did you say you had the 401?
30.
Your Honor, I'd like to pass up this to the witness. I'll give some copies. Done. Ms. Blair, have you seen this document before?
Yes,
What is it?
it's the contribution agreement between John David and Parthenon,
What's the date of this document?
July 30th, 2021.
Will you please turn with me to page 4?
Your Honor, I'm going to object to this document being hearsay unless we can lay a foundation for it.
Your Honor, we'd just like to enter this as for identification purposes. Right now, we do have a custodian of records affidavit in our subpoena, and we have the custodian of records from Parthenon actually here, and she'll testify later.
I'll admit it for the limited purposes of identification at this point in time and reserve your objection.
So Ms. Blair, if you'll turn to page 4. Do you recognize Mr. Blair's signature there?
Yes,
Okay. And please turn to the next page. Do you see Mr. Blair's name on this page?
yes,
What does it indicate here that was his cash contribution
32,000,
and his percentage interest?
10%.
We're done with that document for now. You can put that to the side.
Mark this for identification.
Your Honor, I'd next like to pass up a loan application and agreement. This was obtained from our subpoena to Raymond James. We have that custodian of affidavit record, although I believe we have an agreement to the authenticity with opposing counsel on that, but I can pass that to you if need be.
Is this the loan agreement with Raymond James?
Yes,
Do y'all have a business records affidavit? for
we
it?
do.
I see it. I don't have. No, hold on, Your Honor. No objection if they've got the business records affidavit. No objection, Your Honor.
All right, we'll mark these as a collective exhibit. You want to make us an exhibit?
Yes, Your Honor.
We'll mark the authorization, the affidavit of records custodian along with the loan application will be marked as exhibit 1.
Did I give you one already? Do you have this already? I don't remember if I
know.
handed it
I
to
don't-
you. There you go. Ms. Blair, do you recognize this document?
Yes,
What is it?
it is the loan agreement for my 401k.
And as we discussed here in court already, our office received this pursuant to a subpoena. Is that correct?
Yes,
Will you please read the first paragraph of this agreement, the first full paragraph?
I, Greta Blair, hereby apply for a loan from the account held for my benefit in the Raymond James Financial Incorporated 401k plan in the amount of 35,000. The loan will be repaid by me over 117 payments of $328.94 with a final payment of $328.92 by regular payroll deduction. I understand a one-time $75 setup fee will be deducted from the account the plan holds for my benefit.
Okay, now drop down to part 2A. If you'll read the first sentence beside promise to pay.
I promise to pay to the order of the trustees of the plan the principal sum of 35,000 plus interest of the unpaid balance at the rate of 4.25% per year until the loan is repaid in full.
Now flip with me to the last page. Did you sign this document?
Yes,
How did you sign it?
e-signature,
And what was the date?
7/6/21.
Done with that. Did you and Mr. Blair keep separate or joint bank accounts?
Separate.
Why?
It just worked out better for us that way.
Where do you conduct your banking?
Bank of America.
And throughout your entire marriage to Mr. Blair, did you always conduct your banking at Bank of America? I'm going to pass up some Bank of America records, same thing. I do actually have a copy of the custodian of records for Bank of America, so no objection to those records.
Well,
Ms. Blair, you need a copy as well. Okay, we're going to begin on Bates stamp BOA 00043, just so I think that's what you're looking at, but Ms. Amonette, if you need to get there. What is it? Bates stamp 0000403. There's a lot, so I just wanted to help orient everybody. You're fine, go ahead. Okay. Ms. Blair, do you recognize this document?
Yes,
What is it?
my bank statement for July of 2021.
And your name appears at the top of this document?
Yes,
And what is the first big red heading that we see?
deposits and other additions.
And which account is this for you?
My checking,
And the third line down, what is the date of that highlighted transaction?
7/8 of 21.
And please read the description of that transaction.
Principal trust, principal trust description, DRCR, to Greta Blair,
And what is the amount?
35,000.
And again, what date is this?
7/8 of 21.
And so that's the date that you received that deposit from Raymond James. And principal is who?
That's who I have my 401k with.
Do you believe that this is a true and accurate copy of your bank statement?
Yes.
Your Honor, I'd like to make this formally the next exhibit. Exhibit number 2 is a collective.
we mark this exhibit 2.
Ms. Blair, we're going to turn the page now. Bates stamp 0000404. Read the red heading at the top of this page.
Withdrawals and other subtractions.
Now go to the highlighted portion. What is the first date of the highlighted portion?
7/8 of 21.
Please read the description.
Banking transfer to savings 3884,
What is the amount?
33,000.
And the next line down, date,
7/8 of 21.
description,
Online banking payment to CRD 3922,
and amount.
2,000.
And what were these amounts for? What was happening here?
I was going to transfer these funds to John David for the purchase of his shares.
And we'll come back to this document, so put it aside just for now. Ms. Blair, do you know who Mr. Blair banked with?
US Bank.
Did he bank with US Bank throughout your entire marriage to Mr.
I
Blair?
think so.
I do, yeah. Ms. Blair, do you recognize this document?
Yes.
What is it?
John David's bank statement for July of 21.
And you're familiar with are you familiar with his bank account number?
I see it.
We're gonna go to the first highlighted section. What heading does that appear under?
Deposits, credits,
What date does that occur?
July 28th.
And what does the description say?
Electronic deposit from Bank of America, Greta L. Blair,
In the amount of?
32,500.
And what does this reference?
This references the amount of the buy-in.
And what was the date of this bank statement?
July 21st through August 18th of 21.
Your Honor, I'd like to mark this as the next exhibit, collective exhibit number 3. And we're going to come back to both the US Bank and the Bank of America, so everyone hold on to those. Ms. Blair, did you pay back the loan that you took out of your 401k?
I was paying it back monthly through payroll deduction.
And did you ever fully pay that off?
I did.
How?
I paid it off last year. The remaining balance were proceeds that I got from his life insurance.
Your Honor, I'm going to pass up an exhibit now for demonstrative. Ms. Blair, what, if anything, does this show for the year of, or what is this document?
Total 2021 and 23 amounts for Parthenon investment.
And for 2021, what does it show?
A total of 37,163.72.
And 2022? In the chart on the first page.
Oh, 7,894.56.
And 2023?
Oh, 7,894.56.
2024?
7,894.56.
2025?
3,332.45.
And June 30th, 2025.
6,529.25.
And what does this chart represent?
The amount, the payoff of my loan.
And do you believe that this document is accurate?
Yes.
One moment. Your Honor, I'd like to mark this as the next exhibit,
No objection, Your Honor.
and we will come back to it. Ms. Blair, is this document based on an amortization payment schedule?
Yes.
And why did we do it that way?
Why do we do it that way?
Mhm.
So it could come out of my check monthly, make it easier for me to pay off.
And how much total was your actual investment to Mr. Blair?
For the 401k,
Mhm.
32,500.
And how much total did you take out in your loan?
32,500.
So for 2021, you're asking for a total reimbursement of how much?
37,163.72.
Okay, Ms. Blair, and does that represent the total amounts plus interest?
Yes.
Did Mr. Blair ever have another opportunity after 2021 to acquire another membership interest or greater membership interest in Parthenon?
Yes.
When?
In 2023.
Do you know how much that buy-in was?
18,000.
And did he have the money for that buy-in on his own?
No,
How was that contribution funded?
I took the money from my IRA.
And how did you take that? Was it a loan or was it something else?
I had to pay a penalty, but yeah, I depleted my IRA.
Gonna pass it or not? I apologize, the records are voluminous. I'm gonna pass this, so let's give you this one. There you go. I'll give you 2 copies. This is the Raymond James records as well. Ms. Blair, what is this document?
My IRA monthly statement for August and September of 23.
And did you withdraw anything from this time?
Yes,
How much?
$26,073.36.
I'd like to make this the next exhibit, Your Honor. Believe we're on 4?
5.
5. Okay. These are the same Raymond James records, different excerpt. Ms. Blair, do you recognize this document?
Yes,
What is it?
my year-end 2023 summary.
And what does it show under distribution summary?
A premature distribution of $26,073.36.
And does it show anything else?
Yes, federal withholding of $7,822.01.
So what was that?
That was the penalty I had to pay.
Now we're going to turn back to the Bank of America records. I can find my copy in this. We'll now be on Bank of America record base stamp 000395. Sure everybody's in the same place. Oh, actually, flip one more. 000213. These are the same Bank of America records from earlier, correct?
Yes.
And what does the red heading at the very top state?
Deposits and other additions,
And what is the highlighted date?
9/12 of 23.
What is the description?
Raymond James, description, Greta Blair,
And the amount?
18,251.35.
And the next page? What does this red heading read?
Withdrawals and other subtractions,
And then the highlighted portion, what is that date?
12 of 23.
And the description?
Transfer Greta L. Blair to John Blair,
And the amount?
18,000.
Now grab those US bank records last time. We're going to be on the second page, base stamp 000095. And these are the same US bank records from earlier, correct?
Yes,
And under the highlighted portion, what is that transaction date?
September 13th.
And the description?
Electronic deposit from Bank of America, Greta Blair,
And the amount?
18,000.
Your Honor, I'm now going to pass up another Parthenon plumbing record. Again, we can just mark this for identification purposes only right now. Ms. Blair, do you recognize this document?
Yes.
What is it?
The operating agreement for Parthenon,
And what is the date on this document?
July 30th, 21.
Oh, do we hand her this copy? I think she should have what we're all looking at. Yes, to her. At the bottom there. I
Oh,
think she has it right.
October 6th, 2023.
And what does it say where it says July 30, 2021? Just read that sentence just so we're clear for the court and Madam Court Reporter.
Whereas the members previously adopted and approved that certain amended and operating agreement dated July 30th, 2021.
And what is your understanding that this document is?
This is the second one, this for this additional buy-in.
Now, if you will go to the last page of this document, do you see Mr. Blair's name there?
Yes.
And what is his total cash contribution?
50,688,
And his percentage ownership interest?
19%.
Ms. Blair, how do you know that your contributions to Mr. Blair were loans?
How do I know they were loans?
And we're done with the
Oh,
document. So you
well,
can-
one was from my 401k, one was from my IRA.
At the time of his death, had he paid you back for any part of those loans?
No,
And you overheard opposing counsel mention him paying you certain amounts. Why was he paying you those amounts?
I mean, he often gave me money. I paid all the bills, mortgage, bills, slip fee, car.
So that's what those payments were for.
Correct.
But he had not ever paid you back for
No.
these loans. And was there any agreement between you and Mr. Blair specifically about when those loans would be paid back?
Yes.
When?
When we were starting to receive dividend payments from Parthenon.
And then Mr. Blair passed away before that.
Correct.
Did you rely on your agreement with Mr. Blair when you loaned him the money for the buy-in that you would be paid back?
Yes.
Do you know whether there was a membership redemption agreement once Mr. Blair passed away?
A what?
Membership redemption agreement with Parthenon?
Yes.
Again, ID only for now. We can proffer them when we have our Parthenon Plumbing custodian of records on the stand next. Ms. Blair, do you recognize this document?
Yes.
What is it?
Membership interest redemption agreement.
Excuse me for interrupting. Would you wish to make this an exhibit?
Yes, Your Honor, I believe that Ms. Amonette has an objection to making it an exhibit until she hears from the custodian of records for Parthenon. So identification for now. And Ms. Blair, if you'll turn to the last page of that document. Did you sign this document?
Yes.
Is that your signature?
Yes.
And if you'll turn back to the first page with me under number 1, please read the last sentence in paragraph 1.
The company shall pay the seller $198,500 within 10 days of the payment date of receipt of company's life insurance policy payment on seller.
So where are these proceeds now?
They are in the estate.
And to your knowledge and from your observation, if you didn't contribute the funds for Mr. Blair's buy-ins, would there be any available funds in the estate?
There is his checking and savings also there.
And what is the total amount that you're asking this court to award you today out of the estate?
63,000. Approximately 63,000. It was somewhere. Hang on.
Yeah.
63,237.08.
That's all I have.
Good morning, Ms. Blair. I'm Kristen Amonette. I represent Ms. Crenshaw in this matter. I'm going to ask you some follow-up questions to your direct testimony. As you testify here today, you do not have any type of writing signed by your former husband that he agreed to a loan with you.
No, it was a verbal agreement.
And as you testify here today, you don't have any type of writing signed by Mr. Blair that, or your former passed away decedent husband, that he agreed to repay any sum of money to you.
It was a verbal.
The 401k loan that you took out from your 401k in July of 2021 in the amount of $35,000, it was repaid by you over time via a paycheck deduction, correct?
Yes.
I'm sorry. And the deduction was about $328.94 every 2 weeks. Is that correct?
Yes.
And at the time of Mr. Blair's death on September 1st of 2024, you had been making consistent payments back to your 401k for that $35,000 loan for about 3 years, correct?
Yes.
And the loan was, as I believe you testified, was fully repaid in July of 2025, correct? Okay. And it's your testimony that at that time, you used life insurance proceeds to pay off the loan, correct?
Correct.
And if I'm looking at Exhibit 4, but I just want to establish that the life insurance proceeds that you used to pay off the remainder of the loan was $6,529.25.
Yes.
Okay. So as of today, that loan has been fully repaid, correct? Okay. You testified that you did receive $198,500 for your late husband's interest in the plumbing company after his death, correct? Okay.
I'm sorry, again, how much?
$198,000, $198,000. I think it's 1985. Is that correct? Let's see.
I mean, it's about 198,000. I
Okay.
know it's here somewhere. Oh, yeah, 198,500.
Okay. And you agree that 198,500 exceeds the original loan of $50,000 to your late husband?
Yes.
Okay. I believe you testified that after your husband passed away, you received an insurance payment from Unum.
Yes.
Okay. And was that life insurance on your husband's life? Okay. And was that in the approximate amount of about $30,000?
I thought it was like 25.
Okay. How much in life insurance did you receive after your husband died?
Oh, one for, I think 25 and one for, I think 100.
Okay. And those funds went directly to you, is that correct? Okay. You were the beneficiary, is that correct?
Yes.
Okay. You received a refund for your 2024 income tax return, which you deposited into your checking account. Is that true?
Yes.
Okay. And that was about $19,632. Does that sound accurate to you?
Yes.
Okay. And that was for the year 2024, which was the year that your husband died, correct? And you filed that income tax return married filing jointly. Is that correct?
Yes.
Okay. Your primary checking account, I believe you testified, was the Bank of America checking account. Is that correct?
Yes.
Okay. And isn't it true that your paychecks are automatically deposited into that checking account?
Yes.
Okay. You also make mobile deposits into that checking account. Is that true?
Yes.
And you also make ATM deposits into that account. Is that true?
Yes.
Okay. I'm going to hand you a document right now, just for demonstrative purposes. Now, I submit to you, Ms. Blair, that this is a spreadsheet that my office created. And we have, if you will look at the top, do you see the first date on that spreadsheet?
9/7/21.
And if you look at the bottom, so 9/7/21, that would be after the initial loan, right? and 7 in July of 2021, correct? Okay. And then if you'll look at the last date, what date do you see?
8/7/24.
Okay. And that would be just before your husband passed away, correct?
Yes.
Okay. If you will look behind the spreadsheet at the first page, there's a highlighted transaction dated 9/7/2021. Will you read that transaction out loud, please?
Thank you. Said $200.
$200. Okay. And do you see at the top of the spreadsheet on page 1, the $200?
Deposit?
On the spreadsheet at the very top.
Yeah.
Okay. And so that would have been a mobile deposit that you made, correct?
Right.
Okay. You'll look at the second page. You should see a deposit dated 11/19/2021. Is that correct? And is it a Bank of America mobile deposit in the amount of $1,399.75? Okay. And do you also see that reflected on the spreadsheet? Okay. You'll look at the next page. There's a transaction highlighted 12/29/21. Bank of America mobile transaction for $300. Do you see that? Okay. And is that also reflected on the spreadsheet on the first page? Okay. You'll look at the next page. There's a Bank of America mobile transaction on 1/31/22 in the amount of $7,000. Do you see that? And also one on 2/9/22, a mobile deposit in the amount of $120.65. Do you see that?
Yes.
And are those two transactions also reflected on the spreadsheet?
Yes.
Okay. You'll look at the next page. There's a highlighted transaction dated 4/8/22. It's a Bank of America mobile transaction deposit in the amount of $75. Do you see that? And is that also reflected on the spreadsheet?
Yes.
Okay. If you'll turn to the next page, there's a transaction dated 5/11/22, Bank of America mobile in the amount of $250. Do you see that? Okay. And is that also reflected on the spreadsheet? Okay. And again, these are mobile deposits into your checking account, correct? Okay. And they are not your paycheck, correct? Okay. You'll look at the next page, Bank of America statement. There's a July 25th, 22 transaction from Bank of America, a deposit into your account for $1,600. Do you see that?
I see one for 1,500.
Are you on BO? So are you on, if you look at the bottom of the page, is it BOA 000309? Okay. So just flip the page. There you go.
Yes.
You see 17/25/22 dated mobile deposit in the amount of 1,600? Okay. And is that also reflected on the spreadsheet?
Yes.
You turn to the next page, August 30th, 2022. Is there a Bank of America mobile deposit into your checking account in the amount of $1,530? And is that also reflected on the spreadsheet?
Yes.
If you'll look at the next page, is there a transaction dated 11/21/22 mobile deposit into your checking account in the amount of $3,000?
Yes.
There's a 11/29/22 mobile deposit into your checking account in the amount of $2,500, correct? There's a mobile deposit dated 12/08/22 into your checking account in the amount of $311.28. Do you see that? And there's a 12/9/22 Bank of America mobile deposit in the amount of $600 into your checking account. Do you see that? And are those all reflected on the spreadsheet as well?
Yes.
Yeah. If you look at the next page, there's a January 23rd, 2023 mobile deposit into your checking account in the amount of $5,100. Do you see that? And is that reflected on the spreadsheet? If you look at the next page, there's a transaction, there's two dated 4/24/23 mobile deposit into your checking account, one in the amount of $150 and one in the amount of $50. Is that correct? And are those reflected on the spreadsheet? Okay. You'll look at the next page. There's a transaction, May 22nd, 2023, Bank of America mobile deposit into your checking account in the amount of $3,000. Do you see that? Okay, and is that reflected on the spreadsheet? Okay. The next page, there's a July 10th, 2023 transaction, mobile deposit into your Bank of America checking account in the amount of $1,970. Do you see that? And is that also reflected on the spreadsheet? If you'll look at the next page, there's a transaction dated August 7th, 2023, mobile deposit into your checking account in the amount of $7,000. Do you see that? And is that reflected on the spreadsheet? If you'll look at the next page, there's a Bank of America mobile deposit into your checking account dated September 19th, 2023, in the amount of $250. Do you see that? And is that reflected on the spreadsheet? If you look at the next page, there's a mobile deposit, September 25th, 2023. Bank of America mobile deposit into your checking account in the amount of $3,010. Do you see that? And is that reflected on the spreadsheet? Okay. If you look at the next page, there's a transaction, October 30th, 2023, Bank of America mobile deposit into your checking account in the amount of $1,600. Do you see that? And is that also reflected on the spreadsheet? You'll look at the next page, there's a November 22nd, 2023 Bank of America transaction, mobile deposit into your checking account in the amount of $2,400. Do you see that? And is that also reflected on the spreadsheet? If you look at the next page, there's 3 transactions, one dated 12/27/2023, mobile deposit into your checking account in the amount of $300, another dated 12/28/23, mobile deposit into your checking account in the amount of $5,000, and a third, January 19th, 2024, Bank of America mobile deposit into your checking account in the amount of $604.36. Do you see those? And are those reflected on the spreadsheet? If you look at the next page, there's a February 26, 2024 Bank of America mobile deposit into your checking account in the amount of $3,000. Do you see that? And is that reflected on the spreadsheet? If you will look at the next page, there's a March 25th, 2024 Bank of America mobile deposit into your checking account in the amount of $2,500. Do you see that?
Yes.
And is that also reflected on the spreadsheet? If you look at the next page, there's an April 24th, 2024 Bank of America mobile deposit into your checking account in the amount of $2,000. Did you see that? Do you also see that reflected on the spreadsheet?
Yes.
If you look at the next page, there are 2 transactions. July 29th, 2024 mobile deposit into your checking account in the amount of $2,000, and August 7th, 2024 mobile deposit into your checking account in the amount of $13,000. Do you see those?
Yes.
Okay. And are those also reflected on the spreadsheet?
Yes.
Okay. And so it's your testimony today that these transactions consist of ATM deposits, correct? And mobile deposits into your checking account, correct? And that these are funds in addition to your paycheck, correct? Okay. And the starting date is September 7th, 2021, correct? And that was just after your initial loan in July of 2021, correct? And the last date is August 7th, 2024, correct? And that's before your husband's death on September 1st, correct? Your Honor, I'd like to make this my next exhibit. No objection. So Ms. Blair, just to recap, since your husband's death on September 1st of 2024, you received the home that you all lived in, correct?
Sorry,
You received the home that you all live in, correct?
received the home?
Mm-hmm. Like it was in your name, correct?
Yes.
You guys held it as tenancies by the entirety, correct? Okay. And you received your husband's 401k, correct?
Yes.
Okay. And that's because you were the beneficiary of his 401k. Is that true? Okay. You've also received life insurance proceeds on his life totaling about $120,000 to $130,000. Is that correct?
Yes.
And that's because you were the beneficiary of those funds. True? Okay. And so at this point in time, the funds that comprise the estate consist of some checking and savings accounts funds that were in your husband's sole name, correct? Okay. And also the $198,000 and some change that you received for his interest in the business, correct?
Correct.
Okay. And it's your understanding that your husband died without a will, correct? Okay. And did you search for a will?
I know he didn't have.
Okay, he did not have a will. Okay. And so is it your understanding that under Tennessee law, the beneficiaries of your husband's estate are you as his wife and his child, Caroline Crenshaw. Okay. And you're seeking $50,500, which is the amount of the original loan, correct? Plus the early withdrawal penalty for your IRA, correct? Plus interest on the 401k, correct? Okay, and that totals your requested amount of a little over 60,000, correct? Okay, but you agree with me that during the time period from the loan, original loan in July of 2021 to your husband's death, that well over that amount was deposited into your checking account that was not your paycheck.
But these weren't payments from John David.
I understand.
Yes,
Okay.
these were Christmas bonuses, a lot of them.
Okay.
But they were not payments from John David.
And you see the total of those amounts is over $73,000, correct? Okay. No further questions, Your Honor.
Redirect.
Briefly. Ms. Blair, were those transactions that we just went through, were those from Mr. Blair to you?
He would pay me weekly in cash. I would for bills. And then every once in a while, I would get a certain amount and deposit it. Some of them were, a lot of them were not.
About how many maybe weren't? Just
The
estimate.
big amounts, probably 15, 20,000.
And what of that what was that?
Christmas bonuses from 7 of my brokers.
And we've talked a little bit today about this, you mentioned during your testimony a verbal agreement, correct?
Yes.
And what part of that agreement did you actually perform? The agreement that you had with Mr. Blair, what part did you perform?
We agreed that I would fund the buy-in, our investment, and the agreement was that he would pay me back once dividend payments were made.
And did you take steps to perform relying on that agreement?
Yes.
Your Honor, I have nothing further.
Recross.
No, Your Honor.
Thank you, ma'am. You may step down. All right, we're going to take our mid-morning recess. We'll be in recess for about 15 minutes. All right. All right, we are ready for the next witness.
Sorry, Your Honor, I think we have a good question about the have somebody here for Parthenon to authenticate the documents. I just had a couple of questions for them. I think we've agreed to stipulate the authenticity.
Yeah, Your Honor, we've agreed to stipulate the authenticity of the previously marked for ID only documents.
All right,
I'd like to call this Kerry Thompson.
you'll step around, please, ma'am. You'll raise your right hand and be placed under oath.
That's it.
You are Kerry Thompson, is that correct?
Correct.
And you work at Parthenon Plumbing?
Yes,
And did you know the decedent in this case, John Blair?
I did.
And was he an owner of Parthenon Plumbing,
Yes.
Mr. Blair? Okay, let me show you, and I'm not sure whether it's still up there or not, the contribution agreement. I think was the first one marked for ID. Okay, all right. And I'd like to move that for admission, Your Honor. I don't think there's any objection to it. I don't know, will it be the next numbered exhibit? I guess it will.
Do you want a copy or you?
I've got a
It was
copy.
marked as exhibit, for identification only, I think. And that was the first exhibit, the contribution agreement. So we're gonna now mark that as an actual agreement, as an actual exhibit, which would be the exhibit 7 now.
If you take a look at the contribution agreement, go to the very last page. Do you recognize the signature of Trevor Garrett? And who is Trevor Garrett?
He is the owner.
And was this the instrument by which Mr. Blair first acquired his first ownership interest in Parthenon Plumbing?
It is.
And that was for a contribution of 32,000. If you look at Exhibit A, 32,000, which gave him a 10% interest in the business, correct?
Correct.
And that was dated July 30th, 2021. Take a look at the next one that was marked for ID. It's action by written consent. It's a 3-page document. And I guess we'll make, I'm not sure what the number was on that. We marked it for ID.
I don't think we actually marked these as exhibits because it was as exhibits for identification because it was indicated they were going to be authenticated. So I have the written action by written consent of the majority of members.
Right.
Well,
I just
we want to make that as the next exhibit. It would be 8.
And do you recognize what's been marked as Exhibit 8, the action by written consent of a majority of the members of Parthenon Plumbing, Heating and Cooling LLC? You recognize that document?
I do.
Okay. And you see on Schedule A where the revised ownership is listed, Mr. Blair now has a $50,600 or a total contribution of $50,688. You see that?
Yes.
Giving him a 19% interest.
Yes.
And if you deduct the original 32,000 from that 50,000, that comes out to be $18,688, correct? And that was Mr. Blair's, I guess, second buy-in to Parthenon. Now, if you would take a look at the membership interest redemption agreement dated September 1 of 2024, or as of September 1, 2024. And Your Honor, I just moved that into admission. It was marked for ID. I guess it'll be exhibit
The
number 9.
membership interest redemption agreement. And that will be marked as exhibit 9.
Ms. Thompson, exhibit number 9, I believe was executed after the death of Mr. Blair, correct?
Yes.
Okay. And if you take a look at the next to the last page, where there's a signature there on behalf of Parthenon Plumbing, that's the signature of Trevor Garrett, correct? And who is Trevor Garrett?
He's the,
Okay. He is also one of the owners of
Yes.
Parthenon Pavilion. And is it the amount paid into the estate of J.D. Blair, to the account of the estate of J.D. Blair, was $198,500?
yes.
And that was the increase in value of the original contribution by Mr. Blair at $50,688, correct?
Correct.
That's all I have, Your Honor.
No cross, Your Honor.
Thank you, ma'am. You may sit down and you are free to go. You may call your next witness.
We have no further witnesses, Your Honor.
All right.
I have no witnesses, Your Honor.
You wish to be heard in argument, I'll hear your argument.
Your Honor, as to the statute of frauds issue, which I think is really one of the issues that we're unsettled on. Partial performance, as you've seen from the case law that I've given you, is an exception to this statute of frauds. Here, there was substantial performance on the part of Mrs. Blair. Now, she says the agreement was she would borrow the money from her 401k, certainly as to the 32,000, and she would give it to him, and then he would invest it in Parthenon Pavilion to acquire 10% interest. And the proof is shown that's exactly what happened. When there is partial performance, as there is in this case, the statute of frauds does not apply. As for the argument that it might not have been consummated or might not have been performed within 1 year, there's certainly no proof that it could not have been performed within 1 year. It may very well have been performed within 1 year if the dividends were such that it could be paid. But there is an exception to the statute of frauds where the parties have partially performed, and they did in this case, partially performed. Everything that had to be done other than the repayment was done. And even if going beyond partial performance, promissory estoppel would apply in that case, because she did act in reliance, as she testified, on their agreement. I mean, nobody really wants to get a loan from their 401k and give it to their spouse unless there's a reason for doing so. So she did act in reliance on their agreement in doing that. And the same thing goes for the $18,000, although technically you'd be more unlikely to do that because you're having to pay a huge penalty of $7,000 some odd dollars to the IRS just for liquidating that portion of your 401k in order to make that investment. With regard to the argument that, well, she got proceeds from the life insurance policy, we're not here about that today. That doesn't have any bearing on whether she should first recover her investment before the rest of the amount is distributed. If nothing else, as an equitable matter, there would be no fund whatsoever but for her money deposited in or invested into Parthenon Pavilion. As for the argument that, well, they haven't put on proof that it wasn't paid back. We've got her testimony that it wasn't paid back at the time of his death. But the reality is that you don't have to prove a negative. You don't have to prove that something didn't happen. The proof is that there was an agreement. She relied on that agreement. It was almost completely performed. And then unfortunately, he passed unexpectedly. Her testimony is that it was never repaid. There's been no proof that it has been repaid. And so in the absence of any testimony to that effect, that we've met our burden on that. If you view it, as the court intimated earlier, as a joint asset, technically she's entitled to at least half of it, because half of it would be hers. The fact of the matter is, the proof is shown she was the only person who invested money into that account.
When you talk about it being a joint asset, are you referring to the company that this money went to purchase an interest in?
The ownership interest in that company.
But she got it all, right?
She did not get it all. She has not. We were waiting for we would hope that she would get it all, but we weren't sure about that because technically it is in his name. And he is the decedent, and he died intestate. So instead of taking that money and depositing in her own account,
$198,000 is what we're talking about.
$198,500 is in his estate account, and it hadn't been touched. We didn't want to touch it until we came to you about the distribution of it. And so that's our argument, Your Honor. We think there's been more than partial performance. It's almost completely performed. And thus the statute of frauds doesn't apply in this case. And as an equitable matter, she should get back her investment prior to the increase in that investment being distributed among the heirs.
Your Honor, I want to clarify something for the court. I know that there's been some talk about marital assets and separate assets. And while that's all very relevant in a divorce case, that's not what we have here. We have the law of trust and estates here. And Mr. Blair could have executed a will leaving his whole entire estate to his wife or divided it however he wanted. But he didn't. He died intestate. And so that means that Tennessee law comes in and says, when you die intestate, this is how we're going to do things.
I agree that the Tennessee law says if you die intestate, this is how we're going to do it. But does Tennessee law in probate matters define what is his separate property versus what is marital property? In other words, because of the fact that intestate, a portion of the property would go to his wife and to his heirs. So how do we determine,
Right.
was that property separate or was it marital? And
Well, I would
understand
contend, Your Honor, that anything that accrued during the marriage is marital and that the interest in the business is marital. Just for, but for estate purposes, what's going to happen is whatever's in the actual estate is going to be divided between Miss Blair and Miss Crenshaw equally. Now, what I hear or what has been testified to that's in the estate is that there's 198,000 and some change in the estate, of which half would go theoretically to each party. That is over $50,500, which is the amount of the two original loans. I want to address, Your Honor, our defenses to the claim, though. The first defense to the claim is that there was no writing or instrument where Mr. Blair agreed to a loan or that he would repay a loan. We don't contest that Miss Blair took money out of 401k and her IRA, and that there are transactions which evidence that those monies then went into an account in Mr. Blair's name. And we don't contest that Mr. Blair then used those funds to purchase an interest in this property. But that's not the only, when you look at their agreement, which is the action by written consent of a majority of members, Parthenon Plumbing, Heating and Cooling. It's, let's see, this is dated July 3rd, 2023, it says that Mr. Blair contributed a cash contribution of $50,688 and then financed $153,000 for a total capital contribution making up his 19% of $203,688. So his buy into the company is not solely in reliance on money that he received from the 401k and the IRA. He also financed the largest portion of that. The statute of frauds does require that any agreement that can't be performed within a year be in writing. The defense to that, as stated by opposing counsel, is the doctrine as set forth in this case they submitted of promissory estoppel. And promissory estoppel exists, and I'm reading from the case, where one makes a promise which the promisor should reasonably expect to induce action or forbearance of a definite and substantial character on the part of the promise. And where such promise does in fact induce such action or forbearance, it is binding if injustice can be avoided only by the enforcement of the promise. Your Honor, we don't have that in this case. There's no injustice that's being avoided here. Miss Blair testified she's received life insurance proceeds. She's going to get half of the buyout from the company that they paid the estate. She had over $74,000 in actual cash and ATM deposits during the time between the first loan and his date of death. Her testimony is that the largest portions of those were bonuses or from her employment. But other than her testimony, there's no evidence, Your Honor, that those cash contributions that she made into her ATM and mobile deposits weren't from Mr. Blair. In fact, she testified some were. We just don't know which ones were and which ones weren't. In terms of our second argument, Your Honor, that there's no evidence. That there was well, so the first one is that there's no evidence that it was in writing. And of course, Ms. Blair testified that there was never a writing. Our second was that the loan, there's no proof that the loan hasn't been paid back, either in his lifetime as shown by the checking account deposits or after his death as shown by what she's received from the company post-death. So Your Honor, we believe that the claim should be denied. Thank you, Your Honor.
All right, you have a response?
Just briefly, Your Honor, we've been at the beginning that there is nothing in writing. As you can understand, usually married couples don't ask for notaries if one promises to do something for the other. They don't go out and make an agreement and have it in writing and hire attorneys. I mean, this isn't at all uncommon, but she mentioned promissory estoppel. Actually, two defenses. One is that there is no need for a writing if you have partial performance and you've got substantial partial performance. Here, even if you don't take that promissory estoppel, is a defense to enforcement of the statute of frauds.
Your argument about partial performance is because she actually withdrew the money and
She
made
did.
a deposit into his account.
Almost every part of their agreement that she reiterated was done before he died. She took the money out, went straight to her account. She gave the money to him. He gave the money to Parthenon. Parthenon issued him an interest in the company on both of those occasions. Those were all parts of their agreement, and she performed. I mean, you say, well, she didn't suffer any detrimental reliance. Well, paying the IRS an extra $8,000 and borrowing the money is, you know, a bit of an imposition on somebody. It is something that she did, but even if we get beyond the need for writing, and whether or not this is accepted because of partial performance, she mentioned promissory estoppel, and again, it meets every single element. A promise was made that should be thought to induce some sort of action. What was the action? The action
What was
was,
the promise?
I'm sorry?
What was the
The promise
promise?
was to pay her back if she would loan him the money to invest in Parthenon. And I keep wanting to say Parthenon Pavilion, Parthenon Plumbing. Maybe I should go to Parthenon.
But wouldn't he be paying her back using marital funds?
He would pay her. Now, the agreement was that when the company started issuing dividends, when they started getting dividends, then he would pay her back. Nobody, of course, nobody expected him to die on September 1 of 2024 or any time in the near future because the man was 57 years old. Nobody expected that death. The only part that wasn't performed was the issuance of the dividends and the payment back to her. But it was a promise to pay her back if she'd loaned him the money. In reliance on that, you know, he could have expected that to induce some sort of action. The action was her borrowing the money and liquidating part of it, giving him the money to invest in Parthenon and for Parthenon to issue him an interest in the company. All of those things happen. So even if you get through partial performance and you say, well, there wasn't enough partial performance, which I think there was plenty, we still got promissory estoppel because an injustice can only be avoided by at least letting her have her investment before it's all divided up. Technically, I think there's an argument that it all belongs to her, but she wants to do what's right by everybody. But at least she wants to get her investment back before it's divided up between her and Mr. Blair's daughter.
Well, and Ms. Amonette is correct. I've been referring to marital property and separate property and so forth because of the fact that typically there are definitions that are granted in our state code to help define and understand that marital property is property acquired during the marriage. And from my perspective, I think of it as this company that was bought into during the marriage. And it may have been using funds that she had separately, but it still constituted a marital asset. The court finds that the proof before me, which is basically undisputed, it may be argued that it is not sufficient, but the testimony of Mrs. Blair is that she had an agreement with her husband that she would fund the purchase of this interest in this business, and she has produced proof that she withdrew from her accounts the money that was used to purchase the interest initially, and that was $32,000, and that she repaid that over a period of time, which totaled with interest $37,163.72. She's also testified that as a part of the agreement that she funded the additional purchase of interest in the property or in the company rather, by funding the $18,000, and she has produced records that establish that. And that she withdrew $26,073.36, and that obviously included, I think, a federal income tax penalty. But in any event, the court finds that she has proven that she made this agreement with her husband and that she did in fact contribute those. So that part is established. The part that bothers me is that that money went in to purchase this business, and this business was therefore owned by him in his individual name, and apparently that was an agreement they made so that it would be considered to be his separate property because of the fact that she loaned him the money. And it was unlike a marital property situation where they agree that, hey, you use some of your money and we'll put this in both our names. They held it in his name only, and apparently that was by agreement. So I find that she is entitled to her claim for the amounts that has been set forth of $63,237.08, and that the funds from the sale of the payment to the estate from this corporation would be Mr. Blair's separate property, and as a result of that, it would be divided equally between the parties, and that this $63,000 would be deducted from the amount before it begins to be divided. So that was the judgment report.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Your Honor.
We have a couple of cases I want to go back to. In re Gladys Patricia Davis.
Your Honor, you want us to prepare the order?
Yes.
Yep.
Well, no.
Good morning, Your Honor.
Good morning.
I have with me, Wendy Lee, step right over. In the petition, it's Gwendolyn Davis Lee. I've known her quite a number of years, and she goes by Wendy Lee. So all this is a case where Miss Lee's aunt, Gladys Patricia Davis, was in Texas in guardianship. We call it conservatorship.
Bayhart County is San Antonio, right? Bayhart County, Texas is San Antonio. Right.
I actually had the wrong city though. It's not El Paso. What's the city? San Antonio. Yes. So there's a couple of things I want to clean up in the order when we do an order, including her.
You might keep in mind San Antonio is where the Alamo is located. So if you ever go to Texas, if you ever go anywhere in Texas, you need to make the trip to the Alamo. So
I would love to do that. I've been to a couple of cities in Texas, but not there. So anyway, before the case was transferred to Tennessee, Miss Davis was actually put in the conservatorship, both of her state and her person, with Miss Lee. And we're just seeking to have that adopted here and have letters issued from this court.
where is she living? Is she?
She's at Vantage Point Village here in Ashland City.
All right, I don't have any problem with agreeing to transfer the conservatorship. Obviously, it needs to be here and where your mother is located and where you are located. So I'll be glad to grant your request to transfer it. So
Thank you, Your Honor. We'll submit an order.
all right, thank you. What was the other one? Oh, in Rebecca Joyce Wilding, is that the one? Clear Recon LLC. versus the estate of Donna Lynn Crowell, Secretary of Housing and Urban Development.
Yes, Your Honor. Craig Smith of Chattanooga Bar. Apologize for being tardy this morning. Got caught in traffic south of Nashville. This is an interpleader action. We were the trustee on a foreclosure of property here in Cheatham County. There were excess proceeds from that foreclosure. We're looking to tender those into the court, less our attorney's fees. I've got an affidavit attesting to the attorney's fees as well as an order of
I'll
default.
go ahead and submit that.
Yes, Your Honor.
Your motion for default will be granted since no one is opposed or appeared to oppose. And the funds from that will be interplayed with the court. The total you're asking for is $4,735.98. Is that correct?
Yes, Your Honor.
All right, thank you. Sounds your order. Thank you.
Thank you, Your Honor.
Yeah, we just need to check on them, see if I need more time and stuff. Why don't we just take an early lunch hour, and then those are the only two cases I've got. Jennifer Robertson's involved in both Holland versus Myrick and also the Phelps versus Phelps. All right, we'll go ahead and take our lunch hour. Be in recess for at least an hour.
All right. We're in recess. Wow.
I'm on, listen, how are you?